about guardianship. My practice involves well more than just guardianship. I mean, I do special needs trusts, I do Medicaid, I do wills, I do powers of attorney as well. So a lot of times when I do a presentation on one topic, I get a question as to, well, do you just do that, or do you do more than that? And the answer is yes, I do more than that. But for the purposes of this evening, that's what the topic of the presentation is. So I don't have a compliance office. I am my HR department. That's the benefit of owning my own firm. So I get to include my brother in the presentation. All right, well, on the slides, on the paper, because that's what we're going to do, because we've already taken up enough of your time with the IT issues, why do I care? I have a brother who has special needs. He has autism, Crohn's, and dyslexia. So you see the picture of us there. And then there's a disclaimer on the presentation. Every lawyer, every professional does that. This is not a replacement to an initial consultation, right? Because every case is different and every situation is different. So I can't stand up here and say, everybody needs guardianship, because that's not appropriate, right? Much like not everybody needs a special needs trust. So as far as the next slide, the summary of topics covered: what is a guardianship? When is a guardianship an appropriate choice? When do you need guardianship? These are all of the things that we're going to cover. So first of all, what is a guardianship? When you have guardianship over someone, you are stripping someone of their civil rights. They do not have the ability to enter into a contract. They cannot be married. They cannot be a fully functioning adult unless you as the guardian says they can. Now let's take a moment back, because that sounds a bit extreme, right? Let's talk about what powers of attorney are, because that's also a valid option too in some cases. Powers of attorney allow that person to retain all of their rights, to do what they want with their stuff as appropriate in their mind. Now, as a power of attorney, when you step into that person's shoes, you're helping them with their finances or their health care, but you're not replacing them unless they're incapacitated, in which case would be. But as far as the concept of a power of attorney, if you have an 18-year-old that isn't quite ready to be a fully functioning adult yet, but has their own opinions and is able to drive a car and is on the diploma track and all sorts of other factors that leads you to believe that they can be a fully functioning adult down the road, because who doesn't need a little help from time to time, then maybe power of attorney is the right fit. But the key with powers of attorney is that they have to have capacity, meaning that they have to be aware of what's going on, they have to be able to answer questions, have a conversation, and I don't mean to sound diminishing when I say that, these are the factors that you consider. So when comparing power of attorney and guardianship, power of attorney is far less invasive, it's far less expensive, because you're not going to court. And so sometimes we'll do power of attorney first, and then we'll do guardianship later. But back to the topic at hand, does everybody understand what I just said? Does anybody have a question? Have a question, ask. Yes?
With power of attorney, are there different levels?
Money in their own name, and they do have the capacity to set up their own special needs trust on the situation. This is more fun than court, I'm telling you. But they can't invest it, maybe. Maybe they don't have that level of capacity, then they can I can draft a power of attorney for that, or maybe it's a specific procedure that they need help with or advice on, then yes, there are different levels, is the short answer.
Okay, so it really depends on the person.
Yes, it does depend on the person, but oftentimes when I have parents that come in that want to do sets of powers of attorney as opposed to guardianship, we don't often do limited because they want to be able to help their child in every instance. Now, that doesn't mean that they do, but I don't want to necessarily bond with my client every week because we made it so limited that they're back and paying another legal bill. I'm not a big fan of that, and neither are they so far anyway. So anyway, back to what is guardianship. So, okay, all right, good. You can see, I didn't know I was standing in front of my own slide, sorry. The fiduciary relationship between a guardian and a ward, an other incapacitated person, whereby the guardian assumes the power to make decisions about the ward's person and property. So, as a lawyer, or even before I was a lawyer, if I'm being honest, I am a nerd, a huge nerd. So we wordsmith all day as lawyers, right? So on the next slide, we'll see the key terms in that definition: fiduciary relationship, guardian, ward, and incapacitated person. And if you go to the next slide, we define what those are. So again, a fiduciary relationship is you're stepping in the shoes. Very similar to if you're serving as somebody's executor, personal representative of their will, power of attorney, trustee. You have a fiduciary responsibility to make sure you're doing what you're supposed to be doing. A guardian is someone who has legal authority to act for somebody else. And then the ward, is the person under guardianship, or the alleged incapacitated person is more the accurate term, but a lot of people call it the ward. So there you go. And then, if you go to the next slide, so my brother, he's a clown. He can make me do all sorts of things, and I'm sure that your loved ones with special needs, or without special needs for that matter, can make you do all sorts of wacky things. So this was before the drumstick dash a few years ago, and my mom, having a good sense of humor, made us wear turkey heads. So the point of this slide is to demonstrate that you know them better than I do. We can meet for a free initial consultation, and I'll expose you to some bad jokes that maybe you'll use later. I don't know. But you know your person better than I will in an hour. And so I will rely on you coming into my office, to let me get to know them a little bit, show wacky pictures. I don't know. I enjoy that. To know what's best for them. And we have a little fun along the way, so that's important. So the definition of incapacitated, which is what they have to be in order to have a guardianship be appropriate, is right here. So it's a lot of fun because if you look at the various pieces, depending on the frame of mind, any one of us could fall into this definition at different times. That's typically funnier with attorneys, I don't know. But anyway, that's the definition of incapacity. Next slide. So practical questions when thinking about whether guardianship is appropriate or not. Do they handle money? Are they responsible? Can they take care of their own healthcare decisions? Or when you go to the doctor's office, are you doing most of the talking? And are you doing most of the talking because they can't do the talking and you're just picking up the slack? Or can they legitimately not ask questions? So my brother has autism and Crohn's and dyslexia, as I've shared, right? And he has challenges, and that's okay. But he also has this challenge. He's almost 24, and I don't know if your kids have this, but my brother has this challenge of being lazy. We help him, but we have expectations of him, and we want him to be successful. And so there are times when he will rely on my mom to talk to the doctor, even though he can do it. So we've had to push and prod and encourage him to grow as he continues to develop. So that's not what we're talking about when I'm asking who does most of the talking with regard to the doctor's office. Do they answer yes to every question? Do they not understand the concept of the stranger? Can they manage money? Can they not? Day to day, what does a day look like? And what would it look like if you weren't there? Or not only weren't there, but weren't there 24/7? What would that look like? And these are all considerations. Next slide. So guardianship, is it appropriate in every case? Anybody want to take a stab at the answer to this question? Is guardianship appropriate in every case of somebody with special needs? Okay. Next slide. So the answer to that is no, it's not a one-size-fits-all. Just like a will is not a one-size-fits-all. Everyone should have a will if they're over the age of 18. I'm not saying that they shouldn't, but every will is different, and every situation and case is different. So why do you need a guardianship? When your child with special needs turns 18, they are a fully functioning adult. And the way that I like to explain this in hearings is that means that they can do everything for themselves, by themselves, without any help from anyone. So do you think that your loved one, aside from having a little bit of help, we all need a little bit of help from time to time, but do you think that they can do everything for themselves, by themselves, without any help from anyone? And oftentimes in a guardianship case, the answer is no. And that's okay. Guardianship is not admitting failure. I have a lot of parents in my office at times that go, gosh, we've been fighting to get to 18, we're at 18 now, and now I feel like I failed because we have to go to court. You're protecting them. That's what you're doing. You're allowing them to be a child a little longer when this is appropriate. As far as disadvantages, you are their person. Legally, they have to talk to you as guardian. There is none of this like sign a paper, you're guardian. So legally, you're in their shoes. So it makes it easier to say when talking to Social Security, which is not fun for any normal person, neurotypical person. But if they call and they want to speak to your child or adult, right, but there's a level of innocence, so I like to think of some of the kids that I work with as continued children. If they want to talk to them, how is that call going to go with Social Security? It may not go very well, because sometimes I have struggles talking to Social Security with the people I have on the phone. So they would have to talk to them. Now that's not to say that they shouldn't talk to them if they're able and if you can help them do that, but I'm just saying that's one set of factors. They can have all of their financial and important healthcare decisions made by somebody that has their best interest in mind. You know, Matt, my brother, does not have a lot of friends. He has some, but not a lot. And when friends come around, you know, and that SSI check comes, you know, a lot of room for taking advantage comes into play. Disadvantages. There is a cost to pursuing guardianship. There is a cost for powers of attorney. There is a cost for legal work. I and some of my colleagues do payment plans. We try to make it affordable when we can, but there is a cost. And when you go to court, you're in front of a judge, it takes extra time to do a guardianship than it does power of attorney. There's biannual reporting. If you don't report to the court on a fairly regular basis, you run the risk of being removed as guardian. So some attorneys will help get the guardianship in place and then they'll remove themselves from the case. I don't do that unless the client specifically asks, which is not most of the time. And then they are considered public proceedings. So in Hendricks County, most of the guardianship cases happen Monday, and I like to call them cattle call because Judge Freezy will have multiple people lined up and will go, and a typical guardianship case takes, I don't know, 20, 25 minutes. So in the course of time of watching a television show, you can strip someone's rights away. What do you guys think about that? It's kind of crazy, right? Now, if it's appropriate, and guardianship's not evil, if you talk to some people about supported decision making as of late, that is a good thing to support them and make sure that they're in the least restrictive alternative that is appropriate to them. But sometimes guardianship is the most appropriate thing. So it just depends after we talk about your situation and what's going on. Am I making sense? Okay. So who can serve as guardian? You see the list, a person named in a power of attorney. So oftentimes in a power of attorney, I will have a guardianship provision in there, just in case that in spite of having the power of attorney, you need a guardian, so they know your preference, a spouse, an adult child, a parent, somebody named in a will, and a lot of different people. So this goes back to the, you know your loved one's special needs better than I do. Matt is not necessarily the most facially expressive. That doesn't mean that he doesn't have feelings. So it's important to factor that in when making decisions like this, because you're not only affecting your life, you're affecting theirs. So there are different types of guardianships. There's temporary, permanent, person and estate. So temporary is more if you have a crisis, and it typically lasts about 90 days. So end of life decision making, or what if there's a minor and there's no one to act on their behalf, that's what a temporary one is. Permanent, though, is a bit of a misnomer. It lasts longer than 90 days, but it only lasts so long as it's needed. So generally, when I have a family that comes in and there's a child that turns 18 and we're talking about guardianship, we're talking about a permanent guardianship that lasts more than 90 days because again, as much as I love bonding with clients, I'd rather not do it every 90 days if I can help it, right? And then person, sounds unfriendly. I mean, I don't want to bill you every 90 days for something that you didn't need in the first place. Person deals with living environment, healthcare decisions, really anything to deal with except money. So if, for instance, that your child with special needs turns 18 and is eligible for SSI, let's say, you have to account for Social Security, or to Social Security, for how those funds are being spent. So oftentimes, like there are levels of powers of attorney, there are levels of guardianship. Is person and estate appropriate or not? Are there assets other than Social Security? Because if so, then the estate and accounting to the court for how those funds are being spent, etc., it may be appropriate. But if it's just SSI, which is a great benefit, but is accounted to through Social Security, you may not need an estate. But what if you have a child who is on the higher end of the autism spectrum who could enter into a contract and be taken advantage of? Then maybe we do need both. It just depends on the situation. This is the general process, so meet with an attorney. I can't emphasize this enough. This is not a do-it-yourself kind of thing. It really isn't. You need to consult with a professional about it because maybe guardianship isn't the right choice. Maybe you've gone to an IEP meeting, not to downplay excellent educators, but maybe you've been to an IEP meeting and they say you can't stay in unless you have guardianship. I have news for you, that's not correct, just so you know. So you don't know if it's the right choice until you consult, until you ask the questions. Then we start off with a physician's report for an adult. Every adult guardianship starts off with a physician's report. That means that the physician has to be convinced, not just the lawyer, but the physician has to be convinced that there's a level of incapacity that makes guardianship appropriate. And then we draft the petition, and then there's a lot of other paperwork, and then we go to court, and then we file all of the necessary paperwork after court. So that really is a broad, stroke of how it works, but that's in general. And then as far as what your responsibilities are, they don't really change a lot. Yeah, you have the filings with the court, those are a little different, but you continue being mom, you continue being dad, you continue to be the loved one to the one with special needs. And I've heard it a lot in meetings, and I've heard it some tonight. I was a parent up until age 18. What changed? Well, legally they're an adult, and that's what changed. So that's why we address this. And as much fun as going to court is, if I didn't invent the system, we're working on making it smoother, but this is the system as it is. So the other thing that is an advantage of guardianship is, what if you have an opinionated loved one with special needs? Anyone? Okay. And what if they don't cooperate? Well, under a guardianship, if it's appropriate, then you can go back to court and they can talk to a judge who isn't you, who isn't mom, who isn't dad, who they have to talk to. And that may help things too in an appropriate situation. Like the child the other day who said, oh, I want all my SSI money so I can go buy gummy bears instead of, what I should be buying. I'm just saying, it could happen. So essentially, continuing on, and I don't just do guardianships for people with special needs. There's, people who are minors, that need guardians for various situations. There are people who have dementia on the elderly side of things that have, not always elderly, but sometimes that's needed. But these are more of the responsibilities. So as far as understanding this whole special needs thing, understanding what the public benefits are, understanding the requirements for the public benefits. Should you have a will? Should you do a special needs trust? Is guardianship needed? Maybe a power of attorney? What's going to happen, not only when you're alive, but beyond that? So I know that this can be confusing. I know it can be overwhelming, which is why we insert bad jokes, because it's fun for us, and sometimes we get laughs, so that's nice. But keep in mind that it's a one step at a time type of deal. I offer free initial consultations. I'm at 96 in Keystone, where the traffic is always lousy. No? Okay. Well, it is, just so you know. So it's going to get better. It is. Once they do all the roundabouts, it's going to be great. So thank you for listening. And does anybody have any questions? Yes?
Is it better to have them start that process before they're 18?
That is a really good question. So I've had clients come and call me when their kid is 12. That's a little early. So how this works is I can file before the age of 18, and we can have the hearing as close to on the 18th birthday as possible, but I will not go into court until they're 18. And that is because until they are an adult, I cannot obtain guardianship. Now, that's for an adult. Now, it depends on the county. Like in Marion County, anybody in Marion County in the audience? Yeah? Okay, well, you'll find this fun. They believe that everybody turns 18 on a Wednesday. Yeah. Isn't that funny? So if your loved one with special needs turns 18 on a Friday, we need to wait till the following Wednesday because that's the day they do uncontested adult guardianship cases. In Hendricks County, typically it's Monday, but Judge Freese is a little bit more flexible, so we do different days depending on the case, but most of the time it's Monday. In Hamilton, it's different, so every case is different and every county is different, but that's what makes it fun, I guess. So, any other questions? Yes, ma'am.
Can you just go into a little more depth? Like my son, he'll be turning 17 in August. Like, when would be a good time to set up a consultation and get the paperwork started? Like, how long does the paperwork take before you actually get the court date?
So the question was when to get the process started, in a nutshell, right? So typically 6 months before they turn 18. And that's because sometimes the doctors can take a while, sometimes, the client can take a while to return things, sometimes we get behind, it happens. So 6 months would be a good thing. Any other questions? Okay, well, I will hand it back over, but if you have any questions, I'll be here all night, well, kind of, but a while longer.
Thank you, Liz. Okay, we've got about another 10, maybe 15 minutes to complete the rest of the material. So I have 3 questions on the screen, and these 3 questions are designed to help determine where you may be in the planning process. Most of the special needs planning process is actually tied up in these 3 questions, and so getting them right is really important. Hopefully you can see, or most can see it. Have you left more than $2,000 to your dependent with special needs in your plan? Kids with special needs need more help. That's why there are IEPs and Medicaid and Medicaid waivers and so forth. But question 1 is, what provision have you made for them? Number 2, have you identified a care provider? That is someone that will either be their guardian or will be their new address if something happens to you. And number 3, where are you at with your beneficiaries on your life insurance and retirement accounts? Because for most of us, that's where most of the money is at if something happened to us, meaning for those that we love. Most of it's in 401ks and 403bs and INPERS and Roths and IRAs and Simples and SEPs and life insurance at work and on our own and so forth. And those things are not controlled typically by wills or other vehicles. They're controlled by the specific instructions that are on each individual policy or account. And so the third question is are you current with that, or has anyone been left out, specifically your child with special needs? Now, I'd like to kind of field some thoughts on this, so we've reached a point of audience participation. So help me out here. What are your thoughts on this? Yes or no? Maybe? What do you think?
Don't jump all at once. Same, you know.
I'm going to opt out because we worked with you in the past, so I know the answers.
I have not done any of them.
I'm sorry, what?
I said I have not done any of them.
Have not done any of them?
Yeah.
Okay. Well, in the interest of time, I'll move forward. Bottom line is if it seemed to ace the exam, you would answer yes to all three questions. Money for the child with special needs, someone to take care of them, and the child with special needs is included on all my beneficiary designations, so they're not going to be left out. Go ahead. So what you might be shocked to learn is answering yes to any of the three questions actually indicates a need for planning. There's a great divide in terms of planning for families that do versus families that do not have a child with special needs. You can't plan like your neighbors or like talk radio would tell you to. We have a whole different set of rules to go by. And in fact, if we plan like everyone else, we actually may create more trouble. We create more problems than we solve. So go ahead. We're going to look at things from a legal and a financial perspective, okay? On the legal front, wills, trust, and we've already covered guardianship, okay? As far as a will is concerned, a will is very important for controlling all assets subject to probate. So this would typically be your automobile or automobiles, your checking, your savings account, your furniture, your personal items, and property that you own. The house, the lot at the lake, the boat, whatever. And so a will for most people is an essential tool to make sure that things go to who you want it to, because if you don't have a will, the state in essence has one for you, and the state determines where your assets go at the time of your death. Now, if you're legally married and an asset is held jointly, then it will pass to the surviving spouse. But in the absence of that, even if you're married at the time of your death, if you die without a will, not all assets typically go automatically to the surviving spouse. In many cases, the surviving spouse has to share in those assets with children of the deceased. And these days, as we all know, it's not unusual to have the his kids, her kids, our kids, etc. Everybody see what I'm saying? So surviving spouses are often shocked to find that they're sharing assets with children that were from the previous marriage of their now deceased spouse. And you can assume who's advocating for those children. Yeah. Okay. All right. So, bottom line is not having a will is not cool. And for those that you love, you owe it to them to do some basic planning and have a will in place. Otherwise, instead of paying a little bit to get a will, you'll be paying in legal fees, or your family will, substantial costs to try to straighten out what you did not make clear prior to your death. Very important. In addition to that, your will is your opportunity to specify who you want the guardian to be for your child or children. So it's your wishes, it's your opportunity to have a voice and to be heard. That's important. Also to pick an executor who's going to run the show, file your final income tax returns, perhaps be in charge of burying you, and on it goes.
Attention transmission center guests, there is a silver Silverado extended cab license plate ASW583 in our east parking lot that needs to move. It's blocking traffic. A silver Silverado extended cab. Thank you.
So, and a will's very inexpensive. It's an incredible value. All right, let's move from wills to trusts. Just quickly, you know, if you picked up a People magazine or a Time magazine some years ago and they were talking about some family's trust, we would automatically assume that that family, what? Had money, right? The Rockefellers, the Kennedys, that type of thing, etc. Well, just like a lot of other things that end up being, in essence, mass-produced and become affordable to the rest of us, trusts have become a very popular tool for people to plan. One of the reasons is because with the will you can decide who gets what, but you really can't decide the when and have exercise more elements of control. So with the trust, you can pick not only who gets what, but when they get it, what they have to do to receive it, what they can spend it on, what they can't. You can exercise a lot of control. Years after you're gone through having a trust, And in addition to that, you get to pick a trustee. That could be a person, it could be a professional, it could be an institutional trustee, lots of options, and that's the person in charge of whatever you leave to a trust. Unless you think, I don't have anything to leave to a trust can be funded with life insurance proceeds or retirement funds. So most all of us have some of that at least, and so a trust can be very useful. Go ahead. Let's come back and answer the questions that we posed earlier. All right, so what's wrong with question 1? We thought yes would be the right answer, but we said then no, yes means a problem. So what possibly could be wrong with leaving money to the very child or dependent that needs the most help? Okay, they're not going to know what to do with it, okay, or someone else may help them spend it. Unfortunately, they take advantage of, as Liz mentioned. Matt has not had a lot of friends, and when he does get a friend, I mean, he's all over it. I'm sure you all have seen that, and he usually will wear somebody out pretty quickly. But if someone really, truly did not have a good heart, he might as well have the placard victim written all over him, because he would, I think, struggle a little trying to discern between one's genuine interest versus their interest in what he has. And we don't want to be gone, and the resources that we left for him that we had hoped would provide a safety net for quality of life for him to end up being somebody else's party. Not fair. So question 1, absolutely. What else is involved with resources and our child or children with special needs? I'm sorry? Right, government benefits. For the government to help, they can't have assets or resources. So literally, if we, by either planning or a lack of planning, leave resources for them, it can actually undermine their eligibility for SSI, for Social Security, Medicaid waiver services, etc. In fact, it's the perfect storm. You're no longer here. Families trying to figure it out, and simultaneously, when they're trying to figure it out, all the government benefits go off the cliff. Can you imagine a worse scenario? And yet, believe it or not, it happens. It happens because in an absence of planning, the default takes things in a very negative direction. In fact, the state law will help ensure that the child inherits, the child that has special needs. It's what I call the fox watching the chicken coop. You got the state law ensuring that they inherit, and at the same time that inheritance then taking the state off the hook for Medicaid and Medicaid waiver services. So very careful planning to help ensure the government benefits stay in place. Please go ahead. All right, $2,000 is the limit, by the way, in the state of Indiana. When they have $2,000, they're toast. And that's Medicaid waiver even under the age of 18. And certainly at age 18, eligibility for SSI. If they have $2,000, they're simply not eligible. That's checking, savings, government bonds, a coin collection, that's UTMA accounts, mutual funds. I mean, you name it, anything that's cash or can be easily converted to cash, the government's going to count. And we use that as a reason to make them ineligible for benefits. I mean, I've even had families get on a Medicaid waiver waiting list, wait some period of time, eventually they're targeted, and because they're $2,200 in a savings account, they're declined. They're simply not eligible for the Medicaid waiver. Yes?
You had talked about if they get like a lump sum, if they get approved for SSI, what happens with that?
Okay, all right. So the question is, what if they get a lump sum? I had mentioned earlier there may be a back payment, $10,000 I even threw out. So the answer to that is presumably if the application is made for SSI at age 18, okay, then in essence they have been running a tab by the food and shelter benefits you've been providing. And so that back payment literally should go to the parent to take care of their tab. You see what I'm saying? So we help families create a food and shelter budget, and then you just keep a list month after month. And then when Social Security kicks in, they're able to pay their tab. And if there's any excess funds left, there are a couple of options. One is to actually spend it, go buy some clothing or do something for their personal use. And the other is something called an ABLE account, and we're going to touch on that very briefly here in a moment. Okay, so keep in mind all these resources, and it's counterintuitive because you would think the best thing I can do is help them save and accumulate, and that's going to bite you in the backside. Go ahead. All right, next slide. So, from a planning perspective, the bottom line is the deck is stacked against you. What I mean is that you've got to go through a labyrinth of steps to get the government benefits, and then the system is set up to, in essence, undermine their eligibility unless you very carefully plan. So, one thing that came about 26 years ago is something called a special needs trust. This, like the Medicaid waivers, again, this is about as close to having our cake and eat it too as we'll get from a special needs perspective. If a special needs trust is a part of your plan, and this is a trust that attorneys like Liz and a few other very, very select group of highly trained professionals can assist in setting up, then this actually creates a safe haven where assets or resources can be placed and it does not count against the $2,000. So let's say as an example like me, I've got 3 kids. There are 2 daughters and Matthew. So Matthew, let's say he gets a third. So let's say I had $300,000 to spread among the kids, so his share would be $100,000. If Matthew's $100,000 goes to his properly established special needs trust, the government will see him as having nothing, maintaining full eligibility for all benefits. So what happens with the money in the trust? It pays for everything the government can't or won't, because the government never covers everything. They're focused on food, shelter, and health care. They are not focused on quality of life. That's not their mission, please understand. It's not that they're mean or bad, but they're safety net. And so the trust pays for everything the government can't or won't. If they can do a part-time job or have employment, great. Everything that they can muster or do on their own for sure. But part of the role of a parent of a child with special needs is always picking up the slack or making up the difference, because it's a struggle for them to attempt to maintain the quality of life that we out of love have provided for them. Does this make sense? And when we're gone, who's going to do that? We don't want that to be subject to charity or the gift from others or this type of thing. So what's left to a trust can help continue your good works after you're gone. Go ahead. Okay, the ABLE account, I mentioned that I would touch base on this. This is new. We've had the ABLE account about 2 years here in Indiana, and there's someone out there from Invest ABLE. From
Amy Corbin. She's quite delightful and a good friend, and she's very knowledgeable about ABLE. She's in charge of it.
Right, so there's a table so you can pick up information on this, but what's an ABLE account? Legislation was passed, it took 7 years, can you believe it? A savings account for someone with a disability, and it takes Congress 7 years to debate whether they're going to do that or not. Wow. But finally, 2014, it became legislation, and then states adopted it, Indiana, I think, in 2016. And so, but this is a savings account can be a savings account for your child, under 18, over 18, doesn't matter. What's in an ABLE account does not count against their $2,000 threshold. The funds can be invested. You can have a debit card. You can access funds to pay for things for them. The only major downside with ABLE accounts is really 2 things. Number one, it's not suitable for estate planning because you have an annual max of $15,000. So it's not going to receive that $100,000 in life insurance proceeds. So it's for smaller amounts of money. And the second downfall, please go ahead, is the fact that there's a lien. So the state has a lien on ABLE accounts. And if they have received Medicaid benefits or Medicaid waiver benefits, that type of thing, then at the time something would happen to your child, the state will seek to take what's in the account as a repayment toward Medicaid benefits that they've had while they're here. So ABLE accounts are largely build up, tear down, save, spend type of accounts, not an effort to amass a substantial amount of money that the state would simply take upon their passing. Everybody follow what I'm saying? But where could the ABLE be helpful? If they have employment. It's a great place to kind of stash that $200 or $300 a month if you want to save what they're earning instead of having to blow it or spend it to keep them under $2,000. Another example would be the grandparent that dies and he or she left $10,000 to each of the grandkids. What am I going to do with the $10,000? It's way over the $2,000. I don't want to spend it. It can be thrown into an ABLE account, immediately solving the issue of staying under the $2,000. So there are a variety of situations where ABLE account can be incredibly helpful. And so we work with clients on this as well. One more. Okay, guardianship covered next. Okay, identifying a care provider. I don't know about you, but the first, for many years in my practice, when it came to deciding, who's going to be a guardian or caregiver, it's a 2-minute conversation with your favorite family member, right? You call up your brother or your sister. We're just updating our plan. Sometimes just wanted to make sure you take the kids. Well, of course, you think you need to ask. You can count on us. No big deal. And then the big caboose called special needs gets attached to your train, and suddenly it's not a 2-minute conversation. If you catch my drift, you get questions like, well, does that include Matthew? Well, Matthew's one of our kids. Or, well, how does that work with Matthew, or this type of thing, or can I think about it and get back with you? And I mean, I had parents sitting across the table from me almost in tears because the family member they felt they could count on was in the I need to think about that mode. Very tough. But what we found is the family in most cases does want to step up. We need to help them step up. And the planning process is designed to do that. If there is government benefits in place that will remain in place, a funded special needs trust, and also, next slide, and one more, a letter of intent, which is a caregiver guide with all detailed information on their lives and how to provide care and all the contacts, etc. It's like a 3-legged stool. The stool will stand. Anything less than those three things, trust, government benefits, and detailed instructions, and families shaking their boots. So by planning, we help families do the right thing. Is this making sense at all? Because we create a scenario that's manageable for them versus one that they're scared to death of. Okay, you can put anything in a special needs trust: property, investment, retirement funds, life insurance, whatever you have can go into a trust. Life insurance can be a helpful tool. I'll tell you what, we're about out of time. What I want to do in just the last couple of minutes, if you pull out your evaluation form, because actually I brought an item that I want to do a quick drawing for, and this is called Where Hope Grows, which is an incredible movie. It stars a young man named David DeSanctis who has Down syndrome. He's actually the lead, and it's a full-length feature film. And it's amazing. You'll enjoy it immensely. Not a lot of time to talk about this movie. It was filmed in Louisville, Kentucky, where David is from. David comes up for the Down Syndrome Indiana Buddy Walks sometimes, this kind of thing. But if you'll do your evaluation form, fill it in quickly, then we'll gather them and we'll do a drawing, and one of you will take this with you. While we're taking just a moment or two for you to complete your evaluation forms, I also want to mention, as a result of being here this evening, I'll be pleased to extend to you, like Liz, a free follow-up consultation. And in your folders is my practice brochure, which has our teen pictures. And Shannon Pinafore is our parent advocate. She has a child on the spectrum as well. She'll be the one to be faithful in reaching out to you. So your evaluation form enables us to effectively follow up and extend that free consultation to you. So if you can finish that up quickly so we can get the drawing done, and any questions while we're, yes?
It's been probably 12 years since you met with you. Would you benefit from doing that again?
Absolutely. Yeah, please come in. There's never a charge to come in for consultation. There's never a charge to come back in for a review meeting. I'm delighted to do that. Absolutely. You're close, by the way. I mean, the office is only a half hour from here. We have families that will drive in from Maryville, South Bend, Shipshewana, and go on the road 5 hours round trip to work with us, because we do more of this than any firm in the state. But you're so very close, so you'll definitely want to take advantage. We also will help coach you on Social Security or SSI and other government benefit issues. So can you help gather, our helper here will gather the evaluation forms. So whatever you can get recorded there, so we can get the drawing done, will be wonderful, and you'll just immensely enjoy the movie.
From kind of our standpoint is those successes, being able to see individuals move to that, and I'll use the school term, least restrictive environment. It's wonderful for me to have individuals who maybe they start with an intake on, and now they don't even have services. They've decided, I don't really need them. I'm doing really well. I've learned all the skills that I need to. There are obviously individuals who will never be that way, but maybe they have moved into where they are at their most least restrictive setting that they're ever going to live in, and that's amazing to be able to see that. Some school districts don't do as well preparing for the transitions. I know you guys, whoever's here, is very lucky to have this district because it doesn't happen across the board. But being able to say, man, when he left, we had no idea that now at 20, 30, 40, depending on the individual, I don't need supports, or I just need to check in once a week. It's pretty amazing because it definitely can get there because things have to fall into place. And as everyone kind of said, do your research, make sure that you are making it the right fit, looking early, thinking early, and always being kind of proactive.